Hi, this is Diane from DNF Properties. And as promised, I said I would come back after my legal update with Gov Hutchinson, which is our attorney for the California Association of Realtors, and give you some information on what I've learned. A lot of the new stuff is pertaining to realtors and our forms and what we need to do and what we don't need to do, and some changes on the forms. But there were some interesting items, especially in the rental law. But one of them that I thought was interesting is the ADUs. California is really pro ADUs. They want us to build these ADU units in our backyard. There was a law, SB 9, that passed a few years ago where you could subdivide your property and essentially have a duplex on each. You could subdivide your land and then have a duplex on each property. That's very hard to do. A lot of cities have red tape associated with it, and very few people have taken advantage of that law because it's just not feasible. But the ADUs, a separate ADU in your backyard is something that is very streamlined now, and it's something that some people can take advantage of if they want an extra unit, either to rent out or to have it for your family. Just to have it instead of expanding your home, you'll just have this ADU separate unit in your backyard. Now, there is a new law that they're trying to pass, or may pass next year, in reference to turning it into a condominium development. So you essentially, what you're going to do is be able to sell the ADU. You're not going to sell the land underneath it, just like on a condo, but you're going to sell the airspace. So that's something that's in the works, and it could be a way for some people to make some money on their property. Small claims is going to go up to $12,500 starting next year, January 1st. It's currently $10,000. So the small claims is going to go up $12,500, and they allow you to have 2 claims a year. If you have a third claim in 1 year, then they limit it to $6,250, I believe. There's a new law too where they're going to limit the years of listing agreement. There's a company somewhere that's lending people money, but then they're making them sign a document that they're going to be the one selling that house, and they'll have a 40-year listing agreement, and that's illegal. So California is capping it to 2 years, so you can no longer have a listing longer than 2 years if you're hiring a realtor. I've never seen them that long. Maybe if it's a land property or a very difficult property to sell, that's going to take a lot longer. They're longer listings, but the average is about 6 months right now. Of course, that's negotiable too. Notaries, we're going to probably see remote notaries in California. Right now, you cannot have, you have to do it in person, but they're talking about having remote notaries. But you can right now hire a notary from another state that's not licensed in California and have your documents notarized virtually. But that will be coming soon. Also starting in January, no, this is in July 1, 2024. If you're a landlord, you cannot charge more than 1 month's deposit, whether the property is furnished or unfurnished. So you can no longer collect 2 months' deposit. 1 month's deposit is the most you can collect from your tenant. Also, if you have a pet, you can collect an additional pet deposit. But if it's a service animal, or if it's a service animal or an emotional support animal, you cannot collect a deposit on those animals. A service animal, you don't have to have any proof. You can usually see it. It's usually visual. If it's an emotional support animal, you can ask the tenant for the reason for the emotional support from a doctor. So you can ask for documentation there. Let me see. There are some, you cannot discriminate tenants if they're Section 8 or any subsidy, government subsidy. So you've got to take all applications equal. You can't say in your advertisement that you won't take any subsidy type of rent. You've got to take them all, and you have the criteria on what you're looking for on a tenant, and you have to apply it to all tenants. Most cities in California have rent control. San Jose has a rent control, and a lot of other cities do, but there's also some cities that do not have rent control. However, in the state of California, in the whole, there is a rent control. So if you're in a city that doesn't have rent control, you're going to fall under the state. If the property is 15 years older, 15 years older, it will have the Tenant Protection Act will apply. So that means that you, if you have 2 units or more, The Tenant Protection Act protects them with rent increases. It also protects them against any evictions. So you have to have just cause, meaning you have to have a reason, a good reason to evict somebody. You can't just say, goodbye, I don't want you anymore. Single family homes are exempt. Those are the only things that are exempt right now. Or a condominium or a PUD if it's a single family. If it's a duplex or more, it falls under the Tenant Protection Act. If you live in a duplex, if you live on one side and rent out the other, then it applies and it's exempt like single family homes. So that's something to consider if you're a landlord. The only reasons, if you have a unit, a duplex or higher, and you want to, the only reasons that you can kick out someone is because they did something against the lease, they broke the lease, or you want to move in as an owner and you've got to be there for at least 12 months or longer. And an owner can be your child, it could be your grandparents, it could be your parents, along that line. It can't be brothers or sisters, it can't be nephews, it can't be nieces. It has to be a child, parent, grandparents, along that line. Or if you have a substantial remodel. And substantial remodel is something where nobody can habitat that property while it's being under construction. I mean, they're probably turning power off, or the water's been turned off, and it has to be for at least 30 days. It has to be substantial. If something like that's happening, then you can give your tenants a notice to vacate. Another thing too, the Just Cause and the Tenant Protection Act only is for people who have a 12-month lease or longer. If somebody stays less than 12 months in your property, then a lot of this stuff doesn't apply. But you've got to be careful, and you got to make sure that it's that timeline doesn't hit. If for some reason you wanted to get your property back to sell it or something like that. That is probably it. If you have any questions about anything, I did mention about HOA just earlier today. There's a lot of stuff going on with the HOAs. If you're buying an HOA, make sure you read those documents. If you don't understand the documents, I have someone who will review them for you. It's very, very important. They're very difficult. There's many, many, many pages, and you want to make sure that you're not going to be in a deficit when you get into this property. Remember, though, that there are lots of HOAs. There are 55,000 of them in California, and 48% of them are self-managed. And when they are self-managed, sometimes they're not managed very well. And the duty of the HOA is to maintain, preserve, and enhance. That's the only duties that the HOA has, and the board of directors that go along with it. So if you have any questions on anything, give me a call, 408-221-6602. I hope you enjoy listening to some of my stuff. And if you have any comments, let me know. Thanks. Bye-bye.